Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at University School of Law and Legal Studies, Guru Govind Singh, Indraprastha University, Delhi, Dwarka. Today we are going to talk about Labour and Industrial Law 1, into which I would be taking lecture number 3, which is on Trade Union Act 1926. When we talk about this act, this is a very important act from the perspective of the trade union. When we are talking about the origin of this act is how this act came into the existence, we are having the historic judgment for this, that is Buckingham Mills case of 1920, in which the Madras High Court granted interim injunction against the strike committee of the Madras Labour Union, forbidding them to induce certain workers to break their contracts of the employment by refusing to return to work. Into this case, what has happened basically, because the trade union leaders, they were talking, the members, they were talking to the conditions of the employees' condition into that particular factory. They were talking to them, and then, but because the Madras High Court has given the injunction, they refused to enter into the premises, and they had been penalized for inducing the employees from breaking their agreement with their employers. So this was the reason for this, and because of this judgment, everybody was very much affected. So it had been again realized in 1921 by Mr. N.M. Joshi and others. He was the General Secretary at the time of the All India Trade Union Congress. Successfully, he moved a resolution into the Central Legislative Assembly recommending the government should introduce legislation for the registration and the protection of the trade union, because they wanted any kind of the legislation by which they could be protected. That's why they moved this kind of the legislation into the assembly. Employers, they were very much against the adoption of such a measure. On the resolution being passed by the Central Legislative Assembly in March 1924, the Indian Trade Union Bills was introduced into the Central Legislative Assembly to provide for the registration of the trade union, and in certain respects to define the law relating to the registered trade union into the province of India. Because at the time, because they wanted to have the separate legislation by which the protection can be given it to the trade union. And the reason for that, and we had so many favorable factors at that time to have the Trade Union Act, because at that time there was a First World War was going on, that's from 1920 to 29, and AITUC was established in 1920. First president of AITUC, that was Lala Lajpat Rai, and later on it split into the other things, that is the other thing. N.M. Joshi and his associates, they were into the favor of this because of the efforts of everyone. The Trade Union Act has been passed, and at the time, initially the name of the Trade Union Act was the Indian Trade Union Act. The Indian word had been removed, so Trade Union Act 1926 came to the existence on a, that is in and for this 1st May in 1926 has been celebrated as a Labour Day. When we are talking about objective of the Trade Union Act 1926, the Trade Union Act 1926 was enacted with a view to encourage the formation of permanent and stable trade union and to protect their members from the certain civil and the criminal liability. I discussed that into that case, historic case, what happened Buckingham Mills case, because this person, they had been restrained to enter into the premises, and anytime the members could be arrested and they could be imprisoned. So into this act, they were demanding for the formation of a permanent and stable trade union and they were asking for the immunity, that is a protection to be given to the trade union member. Civil and the criminal immunity has to be given. So, with this object, this act has been passed. When we are talking about the Trade Union Act 1926, it contains total 33 sections and the 5 chapters. First chapter is talking about the applicability. This act is applicable all over India, and into which we are having the important definitions, that is a trade dispute and the trade union. So, when we are talking about the trade dispute under this act is because we had the similar kind of the definition, we have taken it under the Industrial Dispute Act, that is under the Industrial Dispute Act 1947, but now this terms has been changed. Under the codes, we are using the term instead of the trade dispute, that is a industrial dispute. So, whom we would be saying the trade dispute is given in section 2G, it means any dispute between the employer and the workman, or between the workman and the workman, or between the employer and the employer, which is connected with the employment or non-employment. So, this is dispute is between whom? Between the employer and the workman. It can be between the workman and the workman, it can be between the employer and the employer, and leading to the employment or the non-employment, or the terms of the employment or the condition of the labor of any person and the workman, means all the persons employed in a trade or the industry, whether or not into the employment of the trader, of the employer with whom the trade dispute arises. Now, we are coming to the trade union. It has been clearly defined in section 2H of the trade union, that is means any combination, it can be any combination, whether temporary or the permanent, formed primarily for the purpose of regulating the relations between the workmen and the employers, between the workmen and the workmen, and between the employer and the employers. So, this is a kind of the combination. It can be on a permanent basis, it can be on a temporary basis, and formally, that is a primarily it is regulating the relations between the employer and the workman, between the workman and the workman, and the employer and the employer, or for imposing restrictive conditions on the conduct of any trade or the business, and includes any federation of 2 or more trade unions. So, it means because the restrictive conditions can be imposed, and if we are talking about the trade union, here they can have 2 trade union, they can have the more federation, they can join together. Normally, we find that if we are talking about the cloth mills, if we are talking about the steel factories, if we are talking about, that is why they unite together, they are having the one trade union and the federation of the unions. Provided that this act shall not affect any agreement between the partners as to their own business. If it is a case of trade union act is because we are having the number is given and they are deciding mutually, they agree upon something and they are imposing the restrictive conditions, but we are having the similar kind of the other things, other act, but they are the exception, they will not be considered to be the trade union, and these are an agreement between the partners as to their own businesses. Sometimes the partners into the partnership firm, they decide something and they set the conditions, that is the responsibility of all the partners. So, that thing will not be coming under the definition of the trade union. An agreement between the employer and those employed by him to such a employment, it will not considered to the trade union. An agreement in consideration of a sale of the goodwill of a business or the instruction of any profession, trade or the handicraft, it will not be coming under the definition of the trade union. Sometimes the employer is imposing the condition upon the employee just to maintain the goodwill of the company, but that is not the trade union. They can impose, they can go for these kind of the restrictive conditions, but it will not come under the definition of the trade union. So, we are having important cases here for the trade union is TK Rangarajan versus Government of Tamil Nadu, that has been decided in 2003. One more case, B.R. Singh versus Union of India 1989. And when we are talking about the second chapter of the trade union is, it talks about the registration of the trade union. What are the requirements, how a trade union will come into the existence, what is the procedure for this? It deals with from section 3 to 14. So, when we are talking about section 3, here the appointment of the registrar is very important, and the role of the registrar is very important, because the registrar is an authority who would be making the registration of the trade union, who had to check whether the trade union they have complied with the provisions which has been mentioned in section 4 and 5 and 6 of this act. This is the responsibility of the registrar. So when we are talking about the role of the registrar for the trade union is under section 6 of the act, registrar is appointed by the appropriate government of a trade union, and the appropriate government can also appoint as many additional and the deputy registrar in a trade union as it deems fit for carrying out the purpose of this act. So there can be have one registrar, there can be have the many registrar, additional registrar can be have, we can have the deputy registrar. This is the duty of the registrar to take the legal obligation under this act. It includes any specific power and the functions of the registrar may by order specify as well as to specify the local boundaries within which addition of the deputy registrar may exercise or carry out those obligations. Because if we are having the more registrar, if we are having the registrar, we are having the deputy registrar, we are having the additional registrar. So the area would be decided, the local limit would be decided, and they would be exercising their jurisdiction into those particular areas. Section 4 is talking about the mode of the registration. We are having the trade union, what is the procedure, how they can go for the registration. So in section 4 of the act, it provides for the mode of the registration of a trade union. According to this section, any 7 or more than 7 members of a trade union may by application apply for the registration of a trade union subject to the following 2 conditions. We need 7 members for the trade union. If they want to register, there can be 7 members or it can be more than 7 members, and they would be going for the registration, but they have to take care of 2 more conditions for this. These conditions are at least 7 members should be employed into the establishment on the date of making of the application. It is very necessary that 7 members has to be from the same establishments where they are doing the work, and at least 10 or 100 members, whichever is less, are employed into the establishment should be part of it or date of making of the trade union. They need a membership of either there can be the 10% or the 100, whichever is the less, they can take into it. But condition is that these 7 members, they must be from the same employment, then they can go for the registration of a trade union. Along with this, in section 5, application of the registration, they have to give the application has to be moved by the trade union, and it deals with every application of a trade union registration must be presented in writing to the registrar. It includes a copy of the union rules as well as the statement of the information listed, which has been mentioned here. So along with this, they must have to abide by the conditions which has been given in section 5. These conditions are, this is the responsibility of the trade union, they must have to comply with these conditions which has been enumerated in section 5, and these are, firstly, the members submitting must mention their names, occupation and the addresses. The name of the trade union members has to be given, and the occupation where they are doing the work, the occupation has to be mentioned, and the addresses of these members has to be given. Secondly, the name of the trade union and headquarter address must be included. What is the name of this union? Because the name is very important, and this name should not to be the identical with the name of the other trade union. So they have to be, they would be giving the name along with the headquarter office has to be included, and finally the titles, name and the ages, addresses and the occupation of the trade unions office holders must be included. Those who are the office bearers, they must have to give who is a president, who is a secretary, who is a treasurer, who is the executive members, and what are the name of these persons, and what are their ages, what is their addresses, and where they are doing the work has to be given. A trade union's executive must be organized in conformity with the Act's requirement before it is registered. So before going for the registration, they must have to go by all these things. for the important cases I am mentioning here is, that is Tirumala Tirupati Devasthanam versus Commissioner of Labour 1995, Registrar of Trade Union Mysore versus M. Mariswamy, ONGC Workmen's Association versus State of West Bengal. Now we are talking about the rules which has been given into the trade union, because we are talking about the registration, everything is important. So section 4, 5 and 6 are very, very important when we are talking about the procedure for the registration of the trade union. Here when we talk about section 6, it enlists the provisions which should be contained into the rules of the trade union, and it provides that no trade union shall be recognized unless it has been established an executive committee in accordance with the provision of this act and its rule, and specifies the following matters. If any of the trade union they want to be recognized, that is only can be done if they are comply with all the provisions, that is a section 4, 5 and 6. Into 6, the matters has to be included, that is name of the trade union, they must have to give the name of this trade union, and the object of the establishment of the trade union, what are the object of this trade union, and purpose for which the fund of the trade union shall be directed, because every trade union they are having in section 15, they are having their general funds. So they must have to mention that for which purpose they would be utilizing their general funds. A list specifying the members of the union shall be maintained. The list shall be inspected by the office bearers and the members of the trade union. How many members they are having, the total number of members into the trade union, and this list has to be inspected by the office bearers of the trade union. The inclusion of the ordinary members who should be once actually engaged or employed in any industry with which the trade union is connected, the condition which entitles a names to any benefit assured by the rules also. So it is not necessary that they cannot take the member, they can take any of the member if they want to join the trade union. So it is not necessary all the members has to be employed into the same industry, same employment. If someone is doing the work into the other industry, they can join it. Then in that case, they would be giving the particulars of this workman. The condition under which any fine or the forfeiture may be imposed on the members, because that is, if the person is, we are not giving the absolute immunity to the trade union member. So into just for maintaining the good governance, they have to mention, that is when the fine can be imposed, what are the grounds for the forfeiture has to be mentioned into the rules of the trade union. The procedure by which the rules can be amended, varied and they rescinded. They must have to specify, they have to be very, very clear. If they want to go for the change of any of the rule, what is the procedure, how many members would be giving the consent, how many members has to be agree with this kind of the motion. So what is the procedure for making the amendment? If they want to make any kind of the change, they want to vary any kind of the rules, they must have to be, the things has to be very, very clear. If they want to rescind anything, then in that case the thing has to be how many members would be agreeing for these kind of the motions, has to be, the things has to be ready. The manner within which the members of the trade union and the alternative workplace office bearers of the trade union shall be elective and removed. What is the procedure for the elections, how they would be, what are the grounds when they can be removed from the positions. The safe custody of the funds of the labor union and annual audit in such a manner as may be prescribed of the accounts thereof, and adequate facilities for the inspection of the account books by the workplace office bearers and the members of the labor union. So where they would be taking, how this general fund can be utilized and how they would be taking care of this fund. If the someone is, because it is very, very necessary, if the someone is having the fund, the person would be has to be ready for the audit part. For the government send someone for the auditing, because we are having the tripartite system where the employer, employee and the government is involved for the better governance. So what is the system for the auditing here? That is, they would be going by the particular procedure which has been prescribed under this act. They have to follow that procedure only. If someone is coming for the inspection, then in that case they must have to facilitate that person, they must have to be ready with the account books. Everything has to be, that has to be ready, and they must have to mention these things into their rules. The manner in which the trade union can be dissolved. If someone is having the existence, that is not Of course, it is not possible if the trade union is coming, they cannot dissolve. So, sometime we are having the procedure, if they want to dissolve, what is the procedure for the dissolution of the trade union? If they want to amalgamate with the someone, we are having the procedure. So, that particular trade union, they must have to be ready with their own rules, they must have to mention in section 6. Now, in section 7, power to call for the further particulars and require alteration of the name. So, sometime because who would be going for the registration is ultimate authority is the registrar. So, if the registrar thinks so, that the registrar wants more particulars, if the registrar is not okay with the rules which has been mentioned, he is not satisfied, then the registrar can ask for the more particulars, and if the registrar feels so, the other trade union is having the similar kind of the name, having the identical name, then the registrar can convey to them, just go and change the name of your trade union. So, it is clearly mentioned in section 7. This act confers upon the registrar the power to call for the information in order to satisfy him, as that application made under the trade union is in compliance with section 5 and 6 of this act. In matter where the discrepancy is found, the registrar reserves the right to reject application unless such information is provided by the union. Sometime the registrar, if the registrar feels so, that is there is discrepancies there, they have not abide by the rules, they can the registrar is having the power, they can go for the rejections. And this section also confers the power to the registrar to direct the trade union to alter its name, change the name. If the registrar finds the name of the such union to be identical to the name of any other trade union, or if finds the name too nearly resembles the name of any existing trade union, or it may likely to deceive the public or the members of either of the trade union. If the registrar feels so, yes, first is they are having the identical name has been given it to the trade union, and by which, because if we would be having the same name, it would be leading to the public, misleading the public. So, and the registrar can convey to them, change the name of the trade union, so for the better functioning of the this act. Section 8 is talking about the registration, because Section 8 is talking about the registration of a trade union. If the registrar has fully satisfied himself that the union has complied with all the necessary provision of this act, he may register such a union by recording all its particular in a manner which has been specified into this act. Every registered trade union should be a body corporate, which makes it a legal entity with perpetual succession. It have a common seal, the ability to buy, purchase and enter into the contracts with both movable and the immovable property, as well as the ability to show and be showed using that name. When we are talking about, that is the position of the registrar, position of the trade union, that is because this trade union is having the legal entity, and trade union is having the perpetual succession. It is a body corporate. The trade union is having the common seal, and trade union is having the ability, they can through the trade union we can buy or we can possess any of the movable and the immovable property, and the trade union can be shoe and they can shoot the other one. So, this is the and if the registrar is okay with all these things, then the registrar is satisfied with the compliance has been made by the trade union, registrar would be making the registration. For this we are having the other so many important cases. Rangaswamy versus the registrar of a trade union, the Tamil Nadu non-gazetted officers union Madras versus registrar of a trade union, Delhi Police non-gazetted Karamchari Sangh versus Union of India, S.A. Sawant versus State of Maharashtra, in Inland Stream Navigation Workers Union AIR 1936, Chairman SBI versus All Odisha State Bank Officers Association. Section 9 is talking about certification of the registration. If the registrar is okay with the requirements has been mentioned, after making the registration, the registrar would be issuing the certification. So, under section 9 of this act, registrar shall issue a registration certificate to any trade union which has been registered under the provision of section 8 of this act, and shall issue a certificate, that is which is a conclusive proof of the registration of the trade union. That is evident now this trade union has been registered, because once the registrar would be making the certification of the trade union, that is they can hold this is the conclusive proof with the trade union. Now the question comes, for the minimum requirement related to the trade union membership or of a trade union. So, it has been mentioned in section 9A. It talks about that the minimum members of it that is required into the present union is, it has to be, section mandates that trade union shall be registered, must have all the times continue to have not less than 10% or the 100 of the worker, whichever is less, because this is a one of the condition that if they want to have the trade union, minimum members has to be either the 10% of the total or the 100, whichever the less number, they should have hold this much of strength, and subject to a maximum of 7 engaged or utilized in an institution or the trade union which is connected. It is proviso, but the 7 members has to be from the same establishment where they are doing the work. They should be from the similar kind of from the same establishment. So, this is the minimum membership of a trade union. Section 10 is talking about cancellation of a registrations. We are having the grounds where the registrar can go for the cancellation of a registered trade union on the application made by the trade union seeking to be verified in such a manner has been prescribed. This is the duty of the registration. They must have to follow the manner which has been prescribed. If the registrar is satisfied with the fact that the trade union has obtained a certificate by means of a fraud or deceit, but if the registrar feels so, they have received, they had this certificate of the registration and they have applied the means of the fraud or deceit is involved here, and if feels so, the trade union has ceased to exist. Now, this trade union is not existing, and if the trade union has willfully or after submitting a notice to the registrar contravened any of the provision of this act and has been continuing with it, the rule which is in contravention of this act. This is if this is very much sure with the registrar that this trade union has done the contravention of the rules which has been mentioned under this act, is that they can go for the registration, they can go for the cancellation of the trade union. If any union has rescinded any of the rule which has been provided in section 6, if they are not applying the rules which has been given in section 6, again the registrar is having the power, they can go for the cancellation of the trade union. Now, in section 11, that is comes appeal. Any trade union which is aggrieved by the refusal to the registrar or withdraw of a registration made by the registrar, that is they can go for the appeal, because the registrar is not making the registration of the trade union, or if the registration has been done, then the registrar has withdrawn this registration, then we are having the grounds they can go for the appeal. They can go into the High Court if the head office of the trade union is located into the Presidency town. For the appeal, this is very, very important, that is they can go for the appeal where the head office of the trade union is located. So, they can go into the High Court if the head office of the trade union is located into that Presidency town, in any of the labor court or the industrial tribunal if the trade union is located in such a place where the labor court or the trade union is having, their labor court is having the jurisdiction over this trade union, or if the head office of the trade union is situated in any other location, an appeal can be filed in any court which is not inferior to the court of an additional or the assistant. That is, assistant has chosen a principal civil court or the original jurisdiction. So, they can go to the appeal respectively. Section 12, it talks about register of the trade union. Otherwise, this is not possible to go for the how the correspondence can be made if any of the trade union is not having their registered office. So, section 12 of the act lay down all the communications and the notices of any of the trade union must be addressed to its registered office. So, all the communication would be going into their registered office, and if any of the trade union they are making the changes, they are shifting to some other place or changing the address of the their registered office, they must have to intimate to the registrar within 14 days. This is their duty, and the registrar would make the record of it. They will make the entry into the register which has been maintained for this purpose. In section 8 we had the registration. So, there the registrar would be making the change of address of the trade union into that register. Section 13 is talking about incorporation of a registered trade union. As we discussed earlier, because the trade union is, we are saying that is trade union is, we are saying that is a body incorporate, because the trade union is having the name, and trade union is having the perpetual succession, they are having the common seal. The trade union is having the power to contract, and they are having the power to buy movable property and the immovable property, and the trade union, I mean, they can sue the other one and they can be sued with this same name. That is why we are saying the trade union is a body incorporate. We are having section 14 where certain acts not to apply to the registered trade union. These are Society Registration Act 1860, Cooperative Societies Act 1912, the Companies Act 1956, because they are the proviso to the definition of the trade union. They, I mean, on which they look like because we are having, their numbers are more, sometimes they are having the 7 members, more than 7 members, but they will not be governed by the Trade Union Act. Chapter 3rd is talking about rights and the liability of a registered trade union, into which we will talk about section 15 to 28. So, when we are talking about right and liabilities of the registered trade union, that is into section 15, objects on which the general fund may be spent, because how any of the trade union would be doing the work into the industry. So, in section 15, objects on which general funds may be spent. Section 15 of the Act lays down the activities on which a registered trade union can spend its funds. These activities will include salaries, allowances and expenses to be given to the office bearers, because the every trade union, they are having their general funds. From the general fund they would be managing other activities. They would be taking the money from this general fund to take care of the other kind of the objectives. So, that is from this fund only they would be taking care of the salaries or the allowances and the expenses to be given to the office bearers. The cost incurred on for the administration of the trade union, including audit of the accounts of the general fund. So, they would be taking how the administration can be otherwise this is not possible if they are not having any kind of the fund with them. So, they would be taking care of their auditing part from the fund. Conduct of the trade dispute on behalf of the trade union or any member of the trade union. If there is any kind of the dispute is going on, they want to go for the the matters before the court, how they would be maintaining, from where they would be coming with their funds or this thing. So, they would be taking the money from this fund only. Compensation to the workers due to any loss arising out of the trade dispute. Say if there some dispute is going on into the industry. So, at that time I mean how this person would be taking care of the family is, so this kind of the compensation can be given to this workmen from this fund only. Expenses incurred into the welfare activity of the workers. Benefits are conferred to the members or their dependents in case of the death, old age, sickness, accident or unemployment of such a members. So, from the fund the benefit can be given from this fund only. The benefit can be given to the members, or if the person is not alive, to the deceased member family, they would be giving from this fund only. Either it is a case of the death, or it is a case of any kind of the accident has been done, or the person is existing, then in that case if the person is sick, if due to the old age or any kind of the unemployment is there, so they would be giving the money from this fund only. The cost incurred in bringing or defending any legal suit. If any of the legal suit is going on, so they would be taking the money either for the defense purposes or for the prosecution purposes. They would be taking the money from this fund only for the legal proceedings. And publishing materials with the aim of spreading awareness amongst the members, amongst the workers. So, because they want to inform the others, so they need a printed material for it. So, they would be taking the money from this fund only. Provision for educational, social or the religious benefits for the members. that is including the expenses of the funeral or the religious ceremony of the deceased members or their dependents. So, they can take the fund from this general fund only for the any kind of the education, social or the religious activities. And if the person is deceased, then in that case for the funeral purpose or for their religious ceremonies, they can take the money from this fund only. Making provisions for the medical treatment of the workmen, if someone is having any medical policy, they would be giving from this fund only. Section 15 is talking about object on which the general funds may be spent. Taking insurance policies for the lives of the members. Already we have discussed the other points, but these are also important. Taking insurance policies for the lives of the members or under policies ensuring members against sickness, accident or unemployment, because normally we take the policies for sickness and the other things. So, the same is the case with the trade union members. So, this kind of the money can be maintained from these funds. The upkeep of the periodical published mainly for the purpose of discussing questions affecting the employers and the workmen. So, because every trade union, they are having they publish their periodicals, so just to make their workers updated, just to make the awareness amongst the public. So, they take the money from this fund only. The payment in furtherance of any of the objects on which the general fund of the trade union may be spent, or the contribution to any cause intended to benefit the workmen in general. So, if they are getting any kind of the contributions in this thing, they can be spent from this fund. And subject to the conditions contained into the notification, any other object which has been notified by the government. But for this, if they have taken the contributions, so only the 1/4 of the contribution of the money can be spent. If they have received the contributions into this fund, the whole money cannot be utilized by the trade union. This is their responsibility. Only they can spend the 1/4 of the total money. Under section 16 is constitution a separate fund for political purposes, because this fund has been created for the political purposes, and if any of the trade union member is not interested, they do not want to spend for it, no trade union can compel any of the member to contribute for this fund. So, this is the fund where, because this fund is utilized basically for the political reasons. So, for example, if any of the trade union member wants to participate into the legislative elections, they can take the money from this fund only, or any of the local authority elections, they can take the money from this fund only. And for holding any of the meeting or the distribution of any literature, documents in support of this candidate or the prospective candidate, they can take the money from this fund only. Maintenance of any person who is a member of the legislative body constituted under the constitution or the local authority. The registration of the electors or the selection of the candidate for any legislative body, again for the election purposes, they can take the money from this fund only. The holding of the political meetings of any kind or the distribution of the political literature or political document for this. So, they would be taking the money from this fund only. No member shall be compelled to contribute to this fund constituted for this purpose. Any member who does not contribute or does not want to contribute for this fund, so shall not be excluded from the benefits of the trade union. So, the person will not be, they cannot put any person on a very, on any of the disadvantageous positions. So, they cannot compel any of the person for making the contribution. Section 17 is talking about criminal conspiracy in trade disputes, because this was one of the object for passing of the trade union, just to give them the criminal and the civil protection to the trade union members. So, no office bearers or the members of a registered trade union shall be liable to punishment in under subsection 2 of the section 120 of the Indian Penal Code, that is for the criminal conspiracy, in respect of any agreement made between the members for the purpose of furthering any such object of the trade union as specified in section 15 unless the agreement is an agreement to commit an offence. Either they have not entered into, if they are not having this kind of the intention to commit any kind of the offence, they cannot prosecute any of the trade union member for it. Immunity is available only to the office bearers and the member of a registered trade unions for the agreements between the members. Such agreements further any trade union object which has been specified in section 15 of the Act. Such agreements are not to commit offence, because this is very much important. Otherwise, if someone is involved into the criminal activity, the person cannot take the benefit of section 17. So, the Trade Union Act 1926 grants registered trade union immunity, and immunity is not applicable with regard to the legal agreement made by the trade union members for the promotion of the legitimate trade union purpose. So, this kind of the immunity can be given for the legitimate purpose of this act. If we are talking about the case of R.S. Reuker versus Emperor, into the R.S. Reuker versus Emperor, what happened into this case is, here they were involved, the trade union members, they were involved into the criminal conspiracy. Then in that case, they cannot take the advantage of this act. They would be prosecuted if they are involved into any of the criminal conspiracy. Calcutta High Court in G Engineering Works Limited versus Staff, here when they were interpreting this section 17, it has been observed that no protection is, because the Calcutta High Court has very clearly laid down that no protection is available to the members of a trade union for any agreement or commit an offence when a group of workers, large or small, combine to do an act for the purpose of a common aim or object. It must be held that there is an agreement among the workers to do an act, and if act committed an offence, it must similarly be held that it is an agreement to commit an offence. So, no immunity can be granted if all the members they unite and enter into the agreement to commit any kind of the offence. We are having so many important cases, that is on immunity. S.B. Shinde versus State of Maharashtra, R.S. Reuker versus Emperor, Standard Chartered Bank versus Chartered Bank Employees Union, Common Cause versus Union of India, East India Hotels Limited versus Oberoi Intercontinental Hotel Employees Union, Ram Singh versus Ashoka Iron Foundry. So, now we are talking about section 18, equally it is important. Immunity from the civil suits in certain cases. No suit or the other legal proceedings shall be maintainable in any civil court against any registered trade union or the office bearers or the members thereof in respect of the act done in contemplation or furtherance of a trade dispute to which a member of a trade union is a party, on the ground only that such act induces some other persons to break a contract of the employment, or that it is an interference with the trade or the business or the employment of some other person, or with the right of some other person to dispose of his capital or his labour as his will, as we discussed earlier. That is in Buckingham Mills case, because at that time they were talking to their workers, they were not inducing at that time, because these persons they had been prosecuted, they were putting into the prisons on that basis, and they were not allowed to enter into the premises, because the allegation was they are inducing these workers to break their agreement with their employer. This was the thing. So, same is with the case, because no suit or the legal proceeding shall be maintained. So, if they are on that basis, they cannot involve anyone for this. A trade unions shall not be liable in any suit or the other legal proceedings in any civil court in respect of the tortious act done in contemplation or furtherance of a trade dispute by the agent of the trade union, if it is proved that such person acted without the knowledge of or the contrary to the express instruction given by the executive of the trade union. So, when we talk about this point, tortious responsibility of the employer. We are having, otherwise we talk about for the vicarious responsibility, for the act of the servant, for the act of the agent. So normally the employer would be responsible for the act of the partners, but it has been clearly mentioned here, that is for the act of the others, and they are without the knowledge, then the trade union will not be responsible. If they are not into the knowledge, that is the other members or the agent, they are going to commit this kind of the thing, then the trade union will not be accountable for this. In a landmark decision of the Rohtas Industry Staff Union versus State of Bihar, into this case, a certain workman went on an illegal strike and unjustified strike at the instance of the union, because the union told them to go for the strike. A question arose whether the employer have any right of the civil action for the damages against the strikers. The arbitrator held that workers who participated in an illegal strike and unjustified strike jointly and severally liable to pay the damages. From this decision, it is evident that section 18 grants the civil immunity in case of the strike by the members of the trade union. They went for the appeal to the Supreme Court. Supreme Court affirmed the judgment of the High Court on the ground that the claim of the compensation, the award thereof, arbitration proceedings were invalid, and such compensation for the loss of the business was not a dispute or the difference between the employer and the workman, which was connected with the employment or non-employment or terms of employment with the condition of the labor of any of the person. Supreme Court did not decide the question as to whether the Patna High Court was right in relying on section 18 of the Act to rebut the claim of the compensation, because the Supreme Court did not wish to rest its judgment on that ground. If an agent acts without the knowledge of the executive committee of the trade union or against the specific instruction which has been issued by the executive committee not to do that act, then the trade union is not accountable for the torts committed by the agent. We are having the other cases, so many cases, that is the case is Orchid Employees Union versus Orchid Chemicals Pharmaceuticals Limited. Into this, the Supreme Court held that although the trade union and its members, they were restrained to assemble within 100 meters of the boundary of the factory premises of the respondent company and raise the slogans and obstruct the egress of the vehicles carrying out raw material and finish the products, staff buses and the other vehicles into the factory premises and obstruct the loyal workers, foreign customers and the other visitors from entering the premises of the respondent company and getting out of the same till the disposal of the suit or the conciliation proceedings, whichever is earlier. It was, however, observed that the above interim injunction will not in any way interfere with the present appellant's right to strike or the peaceful picketing, because these kind of the activities are not allowed. So that this kind of the right is, they can go for the strike and they can go for the peaceful kind of things. Section 19 is talking about enforceability of the agreement. According to section 25 of the Indian Contract Act, an agreement in restraint of a trade is void. But under section 19 of the Trade Union Act, an agreement between the members of a registered trade union in restraint of the trade activity is neither void nor voidable. However, such a right is available only to the registered trade union, and unregistered trade union have to follow the general contract law. So, if we are talking about section 25 of the Indian Contract Act, that is, it is not considered to be agreement in restraint of a trade. So, this is if any of the trade union is, if any of the trade union they are united, they can go for the, and if it is a registered, they can go for this kind of the practices. So, this kind of the activity of the trade union will not be the void and the voidable. Section 21A, it talks about the disqualification of the office bearers of the trade union. So, we are having the grounds, if any of the member who has not attained the age of the majority, the person can be disqualified. If the person has been convicted by the court in India for the moral turpitude of the cases, that is the person cannot be, person can be disqualified, and unless a period of the 5 years has been, that has been elapsed. So, after the 5 year, again the person can be the member of the trade union, and any of the minor, if the question comes for the minority, any minor can become the member of the trade union. whether the trade union is allowed to change the name. Yes, because it has been clearly mentioned that in section 23, that is, the trade union is free to change the name, but with the consent of not less than 2/3 of its member, and subject to the fulfillment which has been mentioned in section 25. It means the 7 that we will take it now. So, question comes for the amalgamation of the trade union. Yes, section 24 is very clearly on this, and they mention that 2 or the more trade union, they can join together and form one trade union with or without the dissolution of the fund of the trade union. Such amalgamation can take place only when the voting by the half of the members of the trade union has been they are agree with that, or 60% has been casted, the votes has been casted into the favor of this proposal. So, 50% has to be agree in total, because we are having the 2 or more trade union, they are amalgamated. So, total 50% has to be agree, and 60% has to be, they must have to cast the vote into the favor of this proposal. Notice of the change or the name of the amalgamation, because if they want to the change of the name of the trade union and they want to go for the amalgamation, they can go for this practice. So, it is clearly mentioned that in section 29, which is very important, that they can change but and amalgamate, but with the condition is it has to be duly signed by the secretary and the 7 members of the trade union. So, and the same is with the case of the change of the name, the 7 members has to be agreed and it has to be signed by the secretary of the trade union. And when we are talking about notice of the change of the name or the amalgamation is, yes, this is the duty of the trade union is, if they are going for the change of the name of the trade union or the amalgamation, they must have to inform the registrar for this. What would be the effect of the change of the name and the amalgamation? Because if they are going for the change of the name of the trade union or the amalgamation, it is not going to affect the rights and the obligation of the trade union. So, that is, and if the someone is rendered defective or legal proceeding, say for example, if any of the legal proceeding is going on against any of the person, it will continue, it will not, majorly it is not going to affect the trade union. So, they can go for this kind of the thing. Now, the question comes for the dissolution of the trade union. Yes, in section 27, it talks about the dissolution of the trade union. So, if a registered union they want to dissolve, a notice of such a dissolution must be signed by the 7 members and by the secretary. Consent has to be given by the secretary, has to be given. They would be informing the registrar within a 7 days of this kind of the proposal they want to dissolve. Now, section 28, it talks about the returns. Yes, this is the responsibility of the everyone, they must have to file the returns. The same is the case here. So, this is the responsibility of the every trade union, they must have to go for the returns, and for this the return to the registrar annually on or before on such a date which has been prescribed by the registrar. For this, the general statement has to be, if we are talking about the return, it includes the few things which are very important. Into the return, they will talk about the audit report, all the receipt and the expenditure which has been incurred by the trade union, asset and the liabilities of the firm on the 31st day of the December, and they would be, it means they would be giving all the details which has been spent for the functioning of the trade union. In section 29, power to make the regulations. So, under this act, it confers the right on the appropriate government to make the provisions in order to ensure the provision of the act fairly, for make the better execution, they can make the other kind of the rules for this. And the publication of the rules under section 30, it talks about, yes, whatever the rule we have framed it, the appropriate government has framed, they must have to go for the publication of these rules. Now, the question comes for the failure to submit the returns. If any trade union which they had to submit the returns, if they have not done it, then in that case they can be held responsible, and in that case, if they have not done in that way, the penalty can be imposed, and it would be but this is very less penalty has been imposed upon this thing with a fine which can extend to the 5 rupees, and in case of a continuing offence the fine can be extended to 50 rupees per week. So, because and if any person willfully makes or make the false entry or the omission into the general statement which has been required in section 28 of this act is shall be punishable with a fine extendable to the 500 rupees. See, this is the you feel that's why the labor functions it becomes not cannot work to that extent. And a supply of the false information regarding the trade union, either someone has given the false information, then in that case the person would be responsible, and the fine can be imposed for this kind of the act, that would be the 200 rupees. And who would be taking the cognizance of this this kind of the offences? For this, that is when a person is because for the cognizance of the offences, no court which is inferior to the presiding magistrate or a magistrate of the first class shall try an offence under this act, and the court can take the cognizance of the offences under this act only in the following cases: when a complaint has been made with the previous sanction of the registrar, and a person who has been accused under section 32 of the act, he shall be tried within 6 months of the commission of the alleged offence. So, this is from my side. Thank you so much.
I am A.K. Sharma and I am professor of sociology at IIT Kanpur. The question I am going to address is what is urbanization? Urbanization is essentially the process of population concentration, which means that if more people start living in a smaller number of places, or if the distribution of population becomes more unequal, like more people living in places like Bombay, Calcutta, Mexico, then we say that the urbanization is taking place. Essentially, it means increase in percentage of population living in areas or localities which are defined as urban. Urbanization is a new phenomenon, of course, a post-industrial phenomenon. About 200 years ago, hardly 5% population of the world lived in urban areas, and today more than 50% population of the world is living in urban areas or localities which are classified as urban. You will be happy to know that according to 2011 census of India, in our own country for the first time increase in the urban population has been greater than the increase in the rural population, though India is not so urban as the developed countries, and about 31% population of India only is living in urban areas. We can believe that in 10 years, 20 years, 30 years time, India will also be more urban, at least more urban than what it is. It may not be 80%, but certainly it will be 35% or 40%. Now, how is this urban locality defined? Because this definition of locality as urban or rural is crucial to measure level of urbanization. I will give you definition of our own country. In Indian census, an urban locality is defined in two ways. There are statutory towns and there are census towns. All places with municipality, municipal corporation, cantonment or notified town area committees are called urban. This is statutory definition. According to demographic definition, there are three main criteria. If a locality has more than 5,000 people or 75% of male labor force is engaged in non-agricultural activities, or the density of population is 400 per square kilometer or 1000 per square mile, then we say that the locality may be classified as urban. There are many other additions to this definition. Now, we have the concept of urban agglomeration and many other things, but essentially this is how urban population is defined in India. And as I said that urbanization is associated with economic development and industrialization, same is the case with India. About 100 years ago in India only 11% people were living in urban areas, today 31% are living in urban areas, and this is obviously linked with economic development of the country, growth of per capita income and industrialization. I remember that in one 5-year plan it was mentioned that today this urban population can grow by way of natural increase of births minus deaths in the urban areas itself or through rural to urban migration. Today nearly 60% contribution to growth of urban population is due to rural to urban migration, and this is going to increase. This is essentially what urbanization means. Urbanization means growth of population in localities defined as urban in relation to population of localities defined as rural, and I have given you Indian definition. Thank you very much.